As each of us tried to prepare ourselves to cast our vote on April 10th, we recognize that there is a lot of information out there on the ICJ referendum, and this can be overwhelming. One of the biggest challenges has been knowing where to get factual, understandable information in one place. For this reason, we have prepared this video where some of Belize's senior historians answer the most frequently asked questions, and in that process, they walk us through the history, the dispute, and the path to the ICJ. We begin with Mrs. Brenda Armstrong, a lifelong educator who starts off with Belize's birth paper, the 1859 Treaty. Is the 1859 Border Treaty invalid because the road was not built?
In relationship to the terms of the treaty, the fact that one clause that, in this case, Article 7, was not fully implemented, that does not negate the validity of that treaty. There are specific conditions that make a treaty valid or invalid. And one of the primary conditions is that both parties must agree to its invalidity. In this case, the purpose, as stated in the protocol, the preamble to that treaty, the building of a road is not in the preamble. And so the fact that Clause 7 was not fully implemented would have no bearing on the validity of that treaty. And therefore, for people to surmise or guess that the ICJ could rule that Belize could pay is not a logical conclusion. That wouldn't happen.
In consideration of Article 7 of the 1859 Boundary Treaty, Britain offered £50,000 towards the construction of a road that would give Guatemala access to the Caribbean Sea. Guatemala was to provide the labor and ratify the offer within 6 months. Because Guatemala was engaged in war at the time, they did not respond to Britain until 2 years later, and by then, the offer was off the table. Over 80 years later, in 1946, Guatemala declared that they no longer recognized the treaty. His Excellency James Murphy, a career diplomat, will now tell us about all of the attempts to negotiate with Guatemala, who eventually declared that they would no longer recognize the treaty.
What attempts have been made by Belize to resolve the Guatemalan claim on the road to the special agreement and the ICJ option? Why did all these fail?
Belize has been participating in these negotiations since 1962. Innumerable negotiating sessions failed. Why? Guatemala always insisted on some Belizean territory as the price of settlement. What they demanded varied from negotiating session to negotiating session. But sometimes it was Ranguana, Zapadilla, Toledo District, Monkey River South, PG South, Sibun River South. So they varied their demand, but they always demanded Belizean territory. Which Belizean prime minister? Be that prime minister red, be that prime minister blue, is going to sit down at the conference table across from Guatemala and sign away Belizean territory? It's not going to happen. So negotiations failed due to Guatemalan demands. Mediation. In the mid-60s, the governments of Great Britain and Guatemala asked the United States government to mediate the dispute. Initially, the Americans were reluctant to get involved, but eventually they appointed a man by the name of Ambassador Bethuel Webster to serve as the mediator. He took a couple years, presented his proposals in the form of a draft treaty, ultimately rejected by all parties. Basically, the Webster proposals conferred nominal independence on Belize, but in fact transferred responsibility for much of Belize's foreign affairs and defense from Great Britain to Guatemala. Obviously not going to work. 1975, the internationalization process, negotiations between Britain and Guatemala, mediation. Having failed in 1975, Belize launched its internationalization campaign. it had significant success at the non-aligned movement, CARICOM, Commonwealth, at the UN, but the problem was that the various resolutions and declarations of these multilateral outfits were just that, political declarations, not legally binding, and so not particularly helpful at this time. At the time, in the mid-70s, it was very helpful. The facilitation process between 2000 and 2002, facilitators were appointed by Belize and Guatemala. So Sridhar Ramphal from Guyana for Belize, and Mr. Paul Reichler, an American attorney for Guatemala. They came up with a number of proposals for the final settlement of the dispute. The proposals respected the existing land borders between Belize and Guatemala and were generally favorable to Belize. One of the proposals was that the proposals be put to simultaneous referenda within 75 days of the presentation of the proposals. Guatemala reneged, said that they weren't able to keep that deadline to put the proposals to referendum in Guatemala. Then, agreement to establish a transition process and confidence building measures, signed February 2003. Why this is important for us is this agreement established the OAS office on the western border near Benque and established the Group of Friends of Belize and Guatemala to provide political and operational support for the activities stipulated in the agreement. Then there was an agreement on a framework for negotiations and confidence building measures, signed February 2005. The agreement launched a new round of negotiations, and for the first time, the parties acknowledged that the dispute may be beyond the reach of a political settlement, and the OAS Secretary General was authorized to recommend to the parties referral to the ICJ or arbitration any issues that the parties were unable to reach agreement on. To the surprise of absolutely no one, the negotiations launched pursuant to the framework agreement failed, and the Secretary General recommended to the parties referring this matter to the ICJ. And there we come to the special agreement.
Belize's ambassador to Guatemala, His Excellency Alexis Rosado, is arguably the most versed person in relation to the history of the Guatemalan dispute. He provides clear information on the special agreement and addressed several frequently asked questions regarding the ICJ. Do we still need to go to the ICJ even though our independence is recognized?
Well, whereas we got support of the United Nations for our territorial integrity, those are political declarations. They are not enforceable. An ICJ decision would make sure we have our boundaries enforceable, recognized by the United Nations, especially by the Security Council, would have a mandate then to make sure that that decision by the court be not just recognized, but implemented. What we're seeking the ICJ to do is to make sure it tells Guatemala, these are the boundaries, recognize and respect it.
Does the wording in the special agreement legitimize Guatemala's claim?
The fact that the question being put to the ICJ has any and all legal claims, legal is not the same as legitimate. Yeah? And that is why we need the court to go there, because Guatemala does not recognize it. We need the Guatemala to recognize it and respect it. Only a decision of the court can get Guatemala to do that.
Why are we asking the ICJ to determine the boundaries?
Well, the 1859 treaty established the boundaries between Belize and Guatemala, and what we're seeking the court to do is to look at all the law and all the evidence on the basis of international law, and for the court to look at that law, look at the treaties, look at the international customary law, that is, who has lived here and exercised peaceful possession, control, administration, who has the right to self-determination, and look at their precedents. That is, look at all the cases in which they have confirmed over and over again that a boundary, once established, has a legal life of its own, independent of the treaty. So that is what we're seeking the court to do, to just confirm what international law provides. International law based on treaties, customary law, principles of law.
Can the use of the term adjacency zone affect our borders?
In Section D specifically, it says clearly that the CBMs do not constitute a total or partial waiver to any territory, be it land, maritime, or insular, of any of the parties. In fact, we also went further and said that these CBMs, the fact that we agreed to them, accepted them, implemented them, cannot be used by the other party against them. So it is sufficiently clear in the text of the CBMs that it cannot affect us at all.
Why not just seek an advisory opinion instead?
The truth of the matter is that we have had lots of legal opinion, We have had legal opinions commissioned for us. Guatemala has had legal opinions commissioned by them. There have been several independent legal experts who have also studied the matter of the Guatemalan claim and had their own opinions. Now, one thing that is common among all of those is one conclusion, that Guatemala's claim has no legal merit. So we are clear what an opinion would say. What we need is a binding decision of a court, and that is what is missing. Going to the ICJ for an advisory opinion will leave us where we are, because an advisory opinion would not be binding. Guatemala could just ignore it, and so can the Security Council and the entire international community. So it would add no more than what political declarations of the United Nations and other international bodies have repeatedly said, that they support Belize's territorial integrity.
Dr. Gilda Lewis, a historian and educator, broke it down for us. What evidence will be used to win our case at the ICJ?
The 1859 treaty was signed, it was ratified, it is a binding treaty. That will go before the ICJ as the main evidence in Belize's case. But in addition, there was the 1931 exchange of notes, which is also a treaty. The Guatemalans are in writing stating that they regard the 1931 exchange of notes as a corollary. Now, a corollary means that it is attached to something that went before. But if they're saying that the 1859 treaty is null and void, then what was the corollary? You can't have a corollary to nothing. Under international law, there is such a thing called universal, unilateral declarations. If they have declared that 1931 is a corollary to 1859, then they would have to prove that 1859 doesn't exist. Also, in the Libya-Chad case, the ICJ has made it very clear that once a treaty contains a boundary, it doesn't matter what happens to the treaty, the boundary will remain. This is exactly what happened in Libya-Chad, because they had a treaty of friendship and good neighborliness in 1955. But it wasn't a boundary treaty, but it contained a boundary. So when all the friendship and good neighborliness died, I think that Gaddafi thought that the boundary had died as well, and he found out that he was wrong when he went to the ICJ. Reading from what a Guatemalan historian, I guess, named Mr. Portillo,
who has been involved in the whole Guatemalan question for a long time, looking at what he has written, you can come to the conclusion that Guatemala will go to the ICJ and try to claim that the 1859 treaty was a treaty of cession. But there is documentation that in 1857, Guatemala tried to get Britain to agree to a treaty of cession. And Britain said no, they would be prepared to sign a boundary treaty. So in 1859, it became a boundary treaty. Both countries signed it, both countries ratified it. If you rely on the Vienna Convention on the Law of Treaties, a treaty has to be interpreted in accordance with the meaning of the words and the context in which the words have been written. The 1859 treaty starts off in the heading saying it's a boundary treaty. It goes on in the preamble to say it's a boundary treaty. It says boundary, 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 boundary in Articles 1, 2, 4, 3, and 4. So there is no doubt that it's a boundary treaty.
An area of concern for a lot of Belizeans is, what happens if Belizeans vote no to the ICJ? What will that mean for our country? Listen as Ambassador Dylan Vernon breaks it down. What happens if Belizeans vote no to the ICJ?
If Belizeans vote no on the 10th of April 2019, first of all, the government would accept the democratic decisions of Belizeans, who would then have said no to the ICJ option. That decision of no would basically mean that we're, in a sense, back to where we are right now. That is, with the Guatemalan claim hanging over our heads without a clear path to how we resolve it. But we have to suspect that Guatemala, if Belize votes no, and because they have voted yes, will or could claim some sort of moral high ground in that they would have expressed an interest to resolve this at the ICJ and then paint Belize as the unwilling partner. And then that leads to the question of that some have said, let us go back to negotiations. Clearly, that is an option that will have to be considered again. The thing with that is that we all know what has happened with negotiations in the past. They've all failed, and they've all failed for the simple reason that Belizeans will never agree to giving Guatemala what it wants, territory or rights. So we'll be back to square one with that issue. And with a Guatemala that is a bit more perhaps bullish because of its voting yes and Belize voting no, these negotiations might be even more difficult. Some people talk about the international community and how they might react. I think that we can be comforted with the fact that the international community will not abandon the role they have played in trying to promote peace between Belize and Guatemala. However, one would suspect that some could be a little less patient with it in that all the advice they've been given in terms of how the international community works is that we go to the ICJ when we cannot resolve these kinds of disputes.
Well, if Belizeans vote yes, we go to court, to the ICJ. We argue our case, we put our best foot forward, we show all our title to our land, islands and sea, and when the court rules, then that decision is binding because the Guatemalan government and people have already accepted that whatever the court says, they will agree and accept and abide by. Of course, some people say, but we not trust them. And that's why you have the international organizations, the international community, and especially the Security Council of the United Nations that has a mandate to enforce decisions of the International Court of Justice. So getting a yes means that the dispute will end.
And there you have it. Understandable and easy to follow information on many of the questions and concerns that Belizeans have been chattering about. You are now even more prepared to understand the nature of the dispute and the implications of going or not going to the ICJ. On April 10th, 2019, you should be well equipped to make an informed decision for the benefit of the country. You decide.